the CBI to sensationalize this entire affair, to embarrass the party, to embarrass Kejriwal, to embarrass Manish Sisodia before the national media, that they're looking for these national headlines to be spread across the newsprint tomorrow, that this is something that he cannot strongly assert. That this is something that Kejriwal has been opposing, that Manish Sisodia is innocent, and that is the position that Kejriwal will stick to. Of course, the larger question of the remand, we're still awaiting clarity from the trial court. We understand 6 p.m. is when the trial court could give an indication on a remand application of the CBI seeking custody of Arvind Kejriwal for 5 days. Back to you.
All right. Thank you very much, Ashmit, for joining us. So all eyes on the trial court's order in the remand application of the CBI in the Delhi excise policy case. Joining us now to discuss this further is Sanjay Hegde, Senior Advocate of the Supreme Court. Mr. Hegde, what do you think about the chances of Arvind Kejriwal to get relief? Do you think the chances look bleak with each passing day?
Well, it's no more easy as was first thought after the vacation bench Judge Nyay Bindu had given him bail. Now, it's obvious that his challenge to the Delhi High Court staying it will be filed afresh, because the earlier petition that he had filed, he has withdrawn before the Supreme Court. So it is quite possible that sometime this week or next week, even as the Supreme Court vacation bench continues, he may file an application challenging the grant of stay by the Delhi High Court. What the Supreme Court will do with that, we do not know. But in the meanwhile, even as his bail in the PMLA matter is being challenged in the courts, in the Supreme Court and the High Court, he will have to go for regular bail in the trial court. But the trial court in the CBI matter, which is the predicate offense, but the trial court will possibly consider that bail petition in its own time after it decides the question of police remand. Supposing it remands him to police custody and the police have some investigation to do, and afterwards they come back and say, we finished our investigation, we do not anymore need his remand. That's if the CBI comes back and says that. It's only thereafter that normally the trial court considers the question of whether to grant him bail or not. But the difference here is this, that as far as the CBI court is concerned, it will not have to the twin bail conditions which confront the PMLA court. It's an ordinary case of bail before the CBI court. The CBI court will just consider questions like flight risk or what conditions to impose. So getting bail in this matter may not be as difficult as getting bail in the PMLA matter.
Right. Even though, like you said, when it comes to bail, only things that are considered is whether you're a risk to society, whether you may tamper with evidence, or whether you may try to influence witnesses, or you may try to leave the country for that matter, or flee. But when it comes to the core evidence on paper, while both the cases, the CBI case, which is dealing with corruption in the Delhi excise policy case, and the ED case, which deals with money laundering, how is the evidence really to go forward, and what will be the test of evidence in these cases?
See, the CBI case is an ordinary case of corruption. The same allegations that some 100 crores were received, which were used up in Goa, etc., etc., etc. What would the evidence be there as to the actual receipt of the money, as to the who received the money, was the party aware of it, and was Mr. Kejriwal as the head of the party aware of it? That's one set of facts. The PMLA case arises from the Enforcement Directorate's assertion that this money became the proceeds of crime, and that the proceeds of crime were layered and integrated to cause money laundering. So that's a different set of facts. The PMLA case proceeds in one court. The CBI Prevention of Corruption Act proceeds in another court. Both arise from the same set of facts, but the CBI case is the underlying case, often called the predicate offense. if he is acquitted in the CBI case, then there is no case for him to answer in the PMLA. As to when these matters come up to trial, I would not hazard a guess. Neither prosecuting agency seems to be in any great hurry to bring matters to a trial. But the real question is of the grant of bail. And since there are two separate cases, two separate bails will have to be procured.
When it comes to past precedent in the Supreme Court, when it comes to bail, in enforcement directorate matters relating to PMLA and cases of corruption, how do you think the Supreme Court is going to look at these matters? Will there be, of course, there will have to be separate hearings because there are separate cases, but how can the Supreme Court take a larger view of the matter? Is there any kind of precedent to this?
See, there is no barrier to the Supreme Court considering anything. It can consider matters directly from even the trial court. But as a matter of normal practice and procedure, the Supreme Court tells people, petitioners before it, to exhaust every other remedy before they finally come to the Supreme Court. So while the matter regarding the stay of the bail granted by the trial court is was pending in the Supreme Court till today, and will probably fresh proceedings will be instituted, the Supreme Court will consider the PMLA matter. It may well be that the CBI matter will have to traverse the trial court, then the High Court, and then come to the Supreme Court.
Right. Thank you very much, Mr. Hegde, for joining us on the program, giving us your view on the arguments made so far, the evidence, and what really could be the course of action in the next few days. We are awaiting the final orders of the trial court. That's all we have time for here on News Center. Thank you for watching. Goodbye.